Our next and last speaker is Reuven Brandt. He teaches at the University of California, San Diego, works primarily on ethical and regulatory questions that arise in complex reproductive arrangements, on questions about parenthood, and on reproductive obligations. He's affiliated with the Center for Practical Ethics at UCSD, where he's working on a project examining the ethics of altering the genome of mosquitoes to prevent the transmission of malaria, and also on donor-conceived mosquitoes.
Well, I suppose in a way they did I leave my water bottle somewhere down here? Yeah, I'm trying to be environmental and things like that. All right, thank you very much. I'm really excited to be here. I'm very happy that so many people that are sort of non-academics have shown up to give their feedback on these talks. It's something that we don't normally get, and I think it's very valuable and definitely has sort of changed the way I think about some things and how I might frame things as I discuss them in the future. So it's been valuable for me, for sure. Okay, so the position I'm going to try and defend today is maybe a little bit more, as kind of, a kind of middle ground position, and that will make sense as we go through. Where I'm going to argue that I think that gamete providers, which is the terminology I use, because I think that doesn't talk about donation or sale, it's sort of more encompassing, do have inalienable obligations to their genetic offspring, but I don't think that these are parental obligations. So I think that sort of is, I guess, a somewhat more moderate position, and hopefully it won't be sort of too flawed, and I won't get stuff thrown at me at the end of today. We'll see how it goes. Okay. So what I want to do, my talk's going to be in a couple of main parts. The first, I want to examine two kinds of arguments that threaten the claim that gamete providers have ongoing responsibilities towards their offspring. So I'm going to present these two arguments and show why I think they actually don't work. The first is the claim that gamete providers, if they do have obligations, can just transfer these to other people. And this is a view that is somewhat common in the philosophical literature on this issue. I'm going to argue that these responsibilities aren't actually transferable. And another kind of argument that says that, well, creating people who have needs doesn't actually generate obligations for you to provide for those people. And so that's sort of an argument that's put forward by Boonen and McMahon. I want to argue that that argument doesn't really succeed either. Then, with the amount of time that's left, I'm going to make some brief comments about what might and might not give rise to these kinds of responsibilities and what these responsibilities might look like. And some of this last bit is not entirely worked out because it's sort of a new project, so I'm going to use this as an opportunity to maybe bounce some ideas off of people and see what people have to say. And depending on how long it takes me to get to the first part, we'll sort of determine how much time I have to spend on this last bit. Okay, but first I want to motivate the problem a little bit. And why is this question about responsibilities in gamete donation so I think complex, and where are the tensions? So I think, a first natural starting point is to note that many people have very strong intuitions that individuals, especially men, have responsibilities towards the offspring that result from their gametes. And this is, I think, evidenced by the scorn that people have against so-called deadbeat dads who take no interest in their offspring. In sort of accidental pregnancy cases, the fact that we have this sort of rich legal framework for governing child maintenance obligations. And we think that these responsibilities obtain even when precautions are taken and when there's no intention in the part of either party to create a child, so sort of accidental pregnancy cases, right? We think that these responsibilities obtain. So, for example, the use of contraception failures in one-night stand cases. It's worth noting that the law places such an importance in the role of biological ties that men have been found to be a child's legal parent, even in cases of purloined sperm, so cases where there was no sort of voluntary action taken place. And there's a few examples. I'll just talk about one very briefly. So this is case SF. There was a man who attended a party and was intoxicated beyond the point of being able to consent to sexual activity. In fact, there was strong evidence that he sort of had blacked out. In this blacked out state, somebody engaged in sexual activity with him and became pregnant, and then sued him for child support. He argued that he should not be obligated to pay child support because he was the victim of a sexual assault. The court found that this was irrelevant. It found that what was important was the interest of the child, and said that his proper avenue to address this complaint would have been to file criminal charges against the person that assaulted him. But what the court is interested in is the best interest of the child. And so the quote here is, "The child is an innocent party, and it's the child's interest and welfare that we look to. We note that the father could have filed criminal charges against the mother." Right? So it's a pretty extreme example. I'm not saying I agree with this ruling. I don't. But there is this really large importance placed on biological ties, at least traditionally in the law. Right? So I think both legal practice and intuitions about one-night stand case place a lot of weight on the role of causation when determining parenthood. It's not intentions, because in the one-night stand case, there's no intention to create a child. Same in this case, where there was this person who was incapacitated because of excessive alcohol consumption. So voluntary action isn't even necessary for obligations to arise. So what does this mean for gamete donors, right? We're sort of forced to look at what factors give rise to responsibilities towards offspring. Why do we treat gamete providers differently than we do these other kinds of cases? One legal strategy is to just alter the law around parenthood when medical technology is employed. And this is a strategy that some states take. I've referred to these as MPMIS, or Modified Parenthood by Medical Intervention statutes. One example of this is the state of Virginia, where if medical technology is employed during conception, different rules for parenthood obtain. And that might seem like a reasonable way to resolve this problem, but this results in very counterintuitive decisions. So in this case, Bruce versus Bordwin, which is a case in Virginia, there was this woman, Bruce, and she wanted to have a child, and she didn't have a partner. She approached her friend, Bordwine, and asked if he would provide sperm to her. She said that she would not hold him responsible at all. He could have as much or as little involvement in the child's life as he wanted. But she just and they'd never had a romantic relationship before, so it wasn't as if this was some backhanded attempt to have a child with somebody after a relationship had broken down or something like that. So he provided her with sperm. She inseminated herself. This was done outside the auspices of a clinic. And things went well, but then he changed his mind and decided that he wanted to be recognized as a legal parent, and went to court to ask for his status to be recognized. So the court decided that he, in fact, was the legal parent. And the explanation they gave was that the altered rules for parenthood only obtained when medical technology was employed. And in this case, Bruce had inseminated herself by use of a turkey baster. Now, why is this a counterintuitive result? Well, there was much discussion about whether the result would have been different if she would have used a syringe, because that's a piece of medical technology, and that would have sort of triggered this other set of laws. And it seems absurd to think that something as weighty as parenthood is determined by what aisle in the grocery store you buy the implement that you're going to use to inseminate yourself from. That seems absurd. So I think this strategy doesn't work very well at all, for obvious reasons. Okay. So a common approach in the philosophical literature to sort of resolve this problem is to say, well, we can avoid the question of responsibility, of the problem of whether responsibilities arise for gamete providers by saying that if they do arise, these can just be transferred to others, and then we avoid this problem. So it doesn't matter what responsibilities gamete providers have, they just transfer these to the intending parents, right? And the argument's generally made like this. Transfers of responsibility in parenthood are commonplace. Parents often transfer responsibilities for their children towards daycare, schools, babysitters, hospitals, things like this. We shouldn't think that transferring of responsibility is unusual. All that's happening in gamete provision is it's a very large transfer of responsibility from one party to another. I think one good articulation of this is by the philosopher Tim Bain, who says, no doubt there's more to be said about for and against the transfer principle, but I will assume that enough has been said here to make it, or something analogous to it, plausible. So he seems to think that it's a plausible principle and that we don't really have to make that much effort to defend it. But I think that's not true. And so in the next chunk of my talk, I want to try and show a few things. First, I'm going to argue that there's a very important distinction between transfer and delegation, and that this distinction has been ignored largely in the literature governing gamete provision. The second thing I want to show is that the examples offered in support of transfer as a responsibility are in fact only support the permissibility of delegation. And at least under the classic understanding of parental or reproductive obligations more generally, the kind of responsibilities that arise in procreation can only be delegated and not transferred to others. Okay, so keep this in mind, we'll move forward. Okay, so first, I think the distinction between transfer and delegation can be illustrated by the sort of following toy example. We can imagine a student union that has various jobs allocated to different people. We can imagine this person, Mary, who's the internal affairs officer, and she's responsible for producing the newsletter for the student union newspaper. And we can imagine this other person, Peter, and he's the communication officer that's in charge of some other thing. And we can decide that the group has a meeting, and they decide to change the structure of responsibility amongst the officers. So that's at T1. At time 2, they shifted responsibilities around, and now they move the responsibility for the newsletter to the communications officer, so Peter. And Peter then asks his friend Charlie to design the layout of the newsletter for him, because this is something that he's not particularly good at. Okay, so I think if we think about this, and we think about how we would describe this, I think we'd say that at time 2, both a transfer and a delegation have occurred. So we would say that the responsibility to produce the newsletter has been transferred to Peter, and the responsibility to construct the layout was delegated to Charlie. And I think this is not just a semantic difference. It's not just a subtlety in how we use language. I think this reveals a difference in the structure of the responsibilities. So for one, if Peter drops the ball and just doesn't produce the newsletter, I don't know, maybe spends the weekend partying and doesn't get it done, we don't think that Mary, the previous person who had this responsibility, has any special obligation to make sure that responsibility gets fulfilled. That's not the case that she has to go and now make the newsletter because Peter didn't do it. However, we think if Peter's friend drops the ball, right, and doesn't get the layout done on time, Peter does have a responsibility to either do the layout himself or find somebody else to do it, right? And I think it's important to note here that, so the second is the case of delegation. So I think in the case of delegation, the fact that responsibility is retained by the delegator has nothing to do with blame. It's not that we think that Peter did something wrong by asking his friend to produce the layout for him. He might have had good reason to believe that Charlie would do it on time and do it adequately. It's just that he had the responsibility to make sure that it was done, and it wasn't done, right? So I think the key difference here is that when a responsibility is transferred, the transferor has no trace of the responsibility. It's as if that transferor had never had the responsibility in the first place, like what we probably think is the case of Mary, right? She has no obligation to make sure the newsletter gets produced. In the example of delegation, though, the delegator has to take steps to ensure that the obligation is fulfilled and to make up for any failures to do so, right? So we might think that if Charlie fails to produce the layout, Peter has a responsibility to maybe apologize to people whose articles don't get published that week and has to go and do the work himself, even though maybe he's not to blame. He did nothing wrong in having Charlie go about producing the newsletter. Okay. All right, so this I think is a really important distinction. So now what I want to do next is just show that this distinction has basically been ignored in the discussion about responsibility in gamete provision cases. So here's philosopher Juliana Fuscaldo talking about the transfer of responsibilities, and she says, in support of the claim that parental duties are transferable, we already recognize and accept the transfer of at least some of our parental duties, for example, to nannies, tennis coaches, doctors, and teachers. In fact, we regard as negligent, in many cases, a parent who failed to delegate some of their parental duties to someone who could do a better job. So here she slipped from talking about transfer to delegation, has made no clear distinction about what are the examples of transfer and what is delegation. It's unclear whether she thinks this makes a difference at all. Another example is Honora O'Neill. She says this: begetters and bearers have at various times delegated or transferred some of all of their tasks to wet nurses, relations, tutors, servants, foster homes, and schools, including boarding schools, provided that they take reasonable steps to ensure that their children will be adequately reared. They do not breach, but transfer their parental obligations or some part of those obligations. Now again, Honora O'Neill starts by talking about transfer and delegation and ends by just talking about transfer and makes no clear distinction between what's a transfer, what's a delegation, what the structure of responsibility is at the end. Okay. And I think, though, and this it's quite clear that if we take a closer look at the examples offered by Fascaldo and O'Neill, they're all examples of delegation and not transfer, right? So when somebody puts a child in school to get educated or employs a babysitter or daycare service to take care of their child, they haven't transferred their responsibilities, they've delegated them. Why? Because if any of these services sort of fail to do the task appropriately, the responsibility falls back on the delegator to make sure the job gets done properly, right? So I don't think that we can point to the fact that transfers of responsibility are just commonplace in child rearing to defend the transfer of responsibility in gamete provision, because in fact, it's not transfer that's going on, it's delegation that's going on in all these cases, right? So yeah, in each of these cases, parents have the obligation to make up for any shortcomings themselves or find someone else to fulfill these various obligations. This is quite clear in this babysitter example, right? So we can imagine person Jane, who leaves her child in the care of a babysitter who has agreed to watch the child until midnight. The babysitter then calls at 9 p.m. and says he's decided to leave early to go to a party. We don't think that the parent, Jane in this case, can say, oh, well, I've transferred the responsibility away until midnight, so I'm off the hook, let cards fall as they may. We think that she has an obligation to either go home or find somebody else to go and take care of the child, because again, the responsibility hasn't been transferred, it's been delegated. Okay? So I think the key argument here is that we can't point to the fact that transfers are commonplace to defend transfer and gamete provision, because they just aren't. Usually it's delegation that's going on. Okay. Okay, now the fact that I've just shown you a bunch of examples that are examples of delegation and not transfer doesn't in itself demonstrate that transfers of responsibility aren't possible. You might think they are. But I think if we think of the kind of responsibility that's taken to arise in sort of one-night stand type cases, this type of responsibility does not seem to be the kind that can be transferred. Why? Well, consider child maintenance obligations, right? These are taken to be owed to a particular individual, namely the child, right? We think that child support is the right of the child, not the parent. And it seems really implausible that if some person A has a responsibility to some party B, to make sure that a certain sort of state of affairs obtains, that A can then sort of unilaterally alienate this responsibility by having somebody else agree to fulfill it. Okay, so again, I'm going to work through an example to show why I think this seems quite clear. So imagine the following case. We have John, who borrows a book from Bill and promises to return it at the end of the week. John then lends this book to his flatmate Jane once he's done with it, on the condition that Jane takes charge of returning the book to Bill by the end of the week. Jane forgets to return the book before leaving for a weekend trip, but instead leaves it on the kitchen counter. Friday evening, Bill calls asking for his book back. John replies that he transferred the responsibility to Jane, so he'll have to wait till she gets back. We don't think that this is possible, right? It was John who made the promise, who owes the duty to Bill to make sure that Bill gets the book back. The fact that Jane said that she would do it does not absolve John in any way of this obligation whatsoever. If John can go get the book and take it back, he clearly has to do it. Why is this? Well, because John's agreement was with Bill, and John can't enter into an agreement with anybody else but Bill that could possibly absolve him of that obligation, right? I think it seems quite implausible if we thought this was the case. He did delegate, yes. Yeah, he did delegate it. That's correct. Okay, so I think that the structural responsibility here parallels that in child maintenance responsibilities and things sort of in one-night stand type cases, right? We think that the individual has an obligation to the child in one-night stand type cases, and so it seems unclear to me how any other agreement that person could enter into could fully alienate that obligation to that child. The only person that could possibly absolve the person in the one-night stand case of the obligation is the child themselves. And so unless they do that, I think that they're sort of stuck with the obligation. Okay. So far I've argued for two main claims. The first is that there's an important distinction between the transfer and delegation of responsibilities, and the kind of responsibility that obtain in one-night stand cases does not seem to be the kind that can be transferred to other parties. Okay, so now I want to move on to second part, where we look at arguments put forward that deny deny that responsibility arises just because we, in cases where we create individuals with certain kinds of needs. Okay, so I'll start by just putting this point forward. I won't go through all the examples in the literature, but I think that if you do dive it, I think you'll find this to be true. Many who argue that gamete, sorry, I'm using the term donor, it should be provider. Many who argue that gamete providers have responsibility towards their offspring do so on the basis of something like the following principle. When one's free actions put others in circumstances of extreme need, some duty, pro tanto or otherwise, arises to ensure that those needs are fulfilled. And this is sort of a base principle, I think. It seems quite intuitive. If we place people who don't consent to be placed at risk, we have to somehow make sure that harms don't befall them. And I think, this underlies some of our intuitions in one-night stand cases, and perhaps negligence cases more generally, right? So and this will sort of echo some of the things that Professor Weinberg said earlier on. If I'm going down the street with a tanker full of highly infectious material, I have a responsibility to make sure that that infectious material doesn't escape and make other people sick, and if it does, I have to make sure that they get the proper medical treatment and things like that, because I place them at risk. I have to make sure they're not harmed by the risk that I've imposed on them, right? Okay, so there's a few people who try and dispute this principle. They argue that being causally responsible for another person's state of need doesn't necessarily generate duties to fulfill those needs. So I'm going to look at two of these arguments, and I'm going to try and argue that they're not particularly plausible. Okay. The first is an argument put forward by Silverstein and Boonin. They want to argue there's a very important difference between two things. Being responsible for the fact that someone exists or continues to exist, and being responsible for the fact that, given that they do exist, they are in a state of need, right? So I'll call these 1 and 2. They think that we only have responsibilities in case 2. That is when we're responsible for the fact that, given that somebody exists, they are in a state of need. Another way to put this is that cases where, but for our intervention, the individual would exist without being in need. If that obtains, then we have responsibilities, but if we're only responsible in the first sense, number 1, we don't have responsibilities. So, whoa, that came out very small. Okay, so to illustrate this, Boonin gives us 2 cases, and I'm sorry that this formatting was so bad. I'll read the case out. So, we're asked to imagine this case. You're a doctor and confronted with a patient suffering from a severe life-threatening disorder. You're in possession of 2 drugs that can cure the disease. Drug A cures the disease without any side effects. Drug B cures the disease but results in a kidney condition that will require 9 months of blood transfusions to cure you, to cure the patient. You and the patient share the same rare blood type, so you could be the person to provide these blood transfusions, and you negligently administer drug B, the drug that results in this unwanted side effect. Okay. In this case, Boonin thinks that the doctor has an obligation to make sure the patient receives a blood transfusion. Why? Because in this case, the doctor is responsible for the individual in both sense 1 and 2. They're responsible that this individual continues to exist because they cured their disease, and also they're responsible in the sense that given that they do exist, they have this need that they don't necessarily have to have, right? If the doctor would have acted properly and give the proper drug, the person would exist without being in the state of further need. Namely, they wouldn't need these blood transfusions, right? That could be contrasted with the following kind of case, which came out formatted more correctly. You're a hedonist who wishes to engage in a very pleasurable activity. The activity is such that if you engage in it, there's a chance that it will cause some gas to be released that will result in adding a few extra months of unconscious existence to the life of some already comatose violinist. As things now stand, the violinist has no more conscious life ahead of them. But if this gas is released, and if he does have a few extra months of unconscious life added as a result, it will then become possible for you to bring them out of this coma by letting them use your kidneys. So this is sort of a reference to the violinist example again. Right? And in this case, Boonin wants to argue that the hedonist does not have an obligation to hook themselves up to the violinist, right? So if you engage in this activity that just extends the life of this life of this violinist for a few more months, and so they just remain in this comatose state, you don't have to give them your kidneys, or use of your kidneys. And Boonin's explanation for why we feel this way about this case is that the only alternate to this individual would have been sort of no existence at all. Namely, if you wouldn't have acted in such a way that let the gas get released, this person would just no longer exist at all. but they couldn't exist in such a way that they could exist and not have the need, right? And so that's supposed to show that if you're responsible for somebody existing with needs, but they couldn't exist without those needs, you don't have an obligation to fulfill that individual's needs. Okay. All right. So that is the view. Okay. And I think that this conclusion is incorrect. And I think that we can explain. So the first, I think, immediate problem with this view is if Boonin is right about this, then nobody really owes obligations to children ever. Because you can never create a child that could exist without having certain kinds of needs. We're dependent beings. We all rely on other people to sustain us. And so this seems to be an argument in favor of just like reckless procreation without any obligations to our offspring, regardless of the circumstances in which we bring them into existence. This might seem like a terrible reductio of the position. It's just so pernicious that it couldn't be right. And this is a consequence that Boonin foresaw, and his attempt to sort of escape this consequence is he thinks that his example of the hedonist and the comatose violinist shows that being responsible for somebody having certain needs, namely in that case the need of blood transfusion, isn't sufficient to acquire a duty to provide the needs that have arisen. So there's some cases, like in the case of children perhaps, we do have this obligation, but the person who wants to make that claim has to provide more arguments for it, right? He thinks that he's successfully shifted the burden to those who think that obligations arise when we procreate. I don't think that that's actually correct. I think what Boonin's done in this case is actually provided us with a special case that is disanalogous to most cases of procreation. And so we can't really conclude much about procreation from this case. What's the big difference? Well, the big difference is in the comatose violinist case, nobody stands to suffer if you don't provide them with access to your kidney. We don't really think that somebody who has an extra few days or few weeks in a coma, if they're actually comatose, suffers. Whereas we do think that children who are not provided with adequate care do suffer in that case. And so I think that our intuitions in the comatose case do not really smoothly apply to the normal procreation case. And I think that if we shift the analogy slightly so that the violinist does suffer as a result, our intuition changes. So if you imagine the case where you want to engage in this pleasurable activity, maybe you're juggling in the hospital and you know it might hit some gas that might come in and cause this person to have more life, but they won't remain in a coma, right? What will happen is they'll wake up and they'll be in excruciating pain, right? We might think that if you do that, then you do have an obligation to the comatose, or the previously comatose violinist. So when we shift it to make it more analogous, I think our intuitions change, and that gives us reason to doubt that this distinction that Boonin thinks, well, Silverstein and Boonin think does all this work, does actually that much work at all. Really, I think they're building too much into this example because, again, in the case of the comatose violinist, nobody stands to suffer, and that's a really important disanalogy. Okay, and I think, if we imagine this sort of the case of normal childcare, we do recognize that if nobody takes care of a child, they stand to suffer quite terribly. So it's more, the case of normal childcare is more like the modified violinist example, where, so I think our intuitions align there. Okay, I think there's a second response we can give to Silverstein and Boonin, and that's this. And that is that we can, and so what I want to claim is the fact that somebody couldn't exist without being in need does not absolve us of our responsibilities to fulfill those needs. And I think we can clearly see this if we sort of make a sort of more another fictional example where we engineer specific needs into an individual. So you can look at this case. We can imagine a scientist, I'll call him scientist, is studying a series of engineered gametes and discovers that a certain combination will result in a child that will have a good life so long as they regularly receive chemical X. Scientist is able to produce chemical X with ease. Scientist decides to bring into existence the child formed by these gametes, as the dependence on chemical X will enhance the likelihood of having a lifelong connection with the child, right? So we can imagine the scientist is worried that this child's going to grow up and never talk to them again. But if they make them dependent on this chemical that they can synthesize, then they'll have to remain in contact, right? So this is not a very good scientist, but we can imagine the scientist wants to do this. We can ask, does a scientist have a duty to provide their offspring with chemical X? And I think the answer here is clearly yes, even though we might think that this child couldn't exist without having the need for chemical X, right? Because if they would have used a different genetic combination, you'd have a different child emerge, right? So this distinction between responsible for somebody existing and being responsible for the fact that somebody has needs given that they exist doesn't actually do this work of absolving people of responsibility. So I think there's a problem with the work that Silverstein and Boonin want this distinction to do. Okay. Yeah, the answer seems to be yes. And again, if we followed Boonin's reasoning on this case, it seems like it would be perfectly permissible to bring children into existence only to lead them to perish because they couldn't exist without being in need. And that seems like a very bad consequence, which I think should make us think that the theory is implausible. Okay. The second argument I want to look at is an argument put forward by Jeff McMahon. His argument is slightly different. He argues that we have special reason or obligation to provide for the needs of others only when failing to fulfill these needs will make it such that our prior action rendered somebody worse off than they otherwise would be. Okay, so what does Jeff McMahon have in mind here? He gives us this example of the accidental nudge to illustrate this point. So imagine that you're standing on a dock, you're at a party on a dock, and you accidentally nudge somebody, and they fall into the water. They're not a very good swimmer, but you're a very good swimmer. He thinks you have an obligation to go dive into the water and save them. Why? Well, because if you don't do that, then it's the case that a previous action of yours has rendered somebody worse off than they otherwise would have been, right? You put them in a worse state. Right? And so we might think that, and so he thinks that this explains why, this might ground the fact that gamete providers, where he stands on gamete provision is a bit complicated. He thinks that this can insulate us against certain cases where we have obligations towards other people. So on his view then, if you bring somebody into existence, but bring them to existence hasn't made them worse off than they otherwise would be, you have no obligations to them, right? And so he says, at least so long as they have a life that's worth living, a life that isn't so full of suffering that it's worse than no existence at all. And so he thinks that this might get people off the hook in many cases where they act in such a way that results in people having needs, right? So one thing to note, though, at least on Jeff McMahon's view, is it doesn't get gamete providers completely off the hook, right? It means that in cases where their offspring might risk having a life not worth living and they could intervene to prevent that, they have an obligation to then intervene, right? Otherwise, they've acted in such a way, otherwise a previous action of theirs has rendered somebody worse off than they otherwise would be. So he has I guess what follows from his view is a very minimal view of what obligations gamete providers have, namely just to make sure that their offspring have a life that's minimally worth living. And I think other philosophers have similar kinds of views. They will say, well, in the case of reproduction in general, so long as you've produced more good than bad, then you're fine. You're off the hook. You don't have to do any more. But I think that this is also very wrong. I think that McMahon offers an implausibly impoverished view of our obligations to other people. I think that we can have an obligation to prevent avoidable suffering brought about by our previous actions, even when that suffering does not make somebody worse off overall. And so I'll give you, I think this is the last fictional case I'll talk about. We can imagine a case where you've taken a group of kids camping, right? And you know there's certain risks with camping. You might end up with a bee sting and certain kinds of pain and things like that. But you also might be very convinced that this experience of going camping is overall really good, right? It's good. It builds confidence and life skills and all sorts of things that outdoors people. I used to work at a summer camp, so I kind of subscribe to at least some of this. It's very good to take people, kids out into the wilderness and things like that. You can imagine a case you're leading these kids out into the wilderness, and there's a child that is very susceptible to bee stings. They get in terrible pain if they get stung by a bee. You have an antidote that you could administer, right? That could cease this pain from arising, or not cease from arising, but make it end earlier. And so you're out there. This kid gets stung by this bee, right? You think to yourself, well, even if we include the pain of this bee sting, right? This trip still overall will be good for them. The experience will still be overall good for them. So therefore, I have no obligation. Maybe it's a hassle. I have to run back to where the car was and run forward again. I think I'm just not going to do it because, again, on McMahon's view, you only have an obligation if your action makes it the case that a previous one of your if a failure to act makes it so that a previous act of yours has made somebody worse off than they otherwise would be. And that wouldn't be the case here, right? Because overall, the child has still benefited from this trip, even if you don't run back and get the medication to make the pain stop. But I think that this is, but I think we think that's implausible. I think we still have this obligation because you could act in such a way to sort of reduce their suffering, and you're the one who put them at risk of the suffering in the first place. And so that gives you this obligation in this case. Now, you might think that this is just a variety of sort of general duty for easy rescue, but I think that's not the case. Because you can imagine a case, alter this case slightly, where there's the child that you took out on this camping trip, and another child, and both are in need of this medication, and you can only help one. I think it's quite clear, at least to me, that your obligation is the child that you took out, right? Because you put that particular child at risk of this harm, and so you have to. Now you have the obligation to provide them the medication, even though failing to do that hasn't made it the fact that going out on this camping trip was worse for them overall. So, yeah, okay. So that's why I think McMahon's view is problematic. It's too impoverished a view of what our obligations are to other people. Okay, so I think neither Boonin nor McMahon's arguments conclusively show that responsibility does not arise in gamete provision cases. Why? Because I think Boonin's distinction between the two kinds of ways you can be responsible for people just doesn't hold up. It doesn't insulate people from having obligations, and McMahon's view is too impoverished. We can be responsible for fulfilling someone's needs, even if they could not exist without having those needs, and ensuring that our actions do not make others worse off is not exhaustive of the special obligations we have when we place other people in harm's way. So I think none of these arguments are fully successful. Okay, so far, I'm almost out of time. Okay, so far I've mostly provided sort of negative arguments. I've explained why some arguments, some philosophers have put forward for why responsibilities don't arise, in fact, I think don't succeed. But that leaves a whole bunch of other unresolved questions. So I haven't said much about why we ought to think that responsibilities arise in this case. In gamete provision cases. And I think one way to do this is to, again, return to the one-night stand case. And the claim I want to make is sort of is an augmented parity argument. So I want to say that if we're convinced, or we think it's plausible that parents in one-night stand cases have responsibilities towards their offspring, we should think that the case for gamete providers is even stronger, right? Why is this? Well, I'm going to skip talking about the Thompson stuff. Even if we accept that there are problems with drawing exactly where to draw the line in the causal chain where we're going to attribute responsibility, which is something that Professor Brake mentioned earlier on, there's a factor in gamete provision that I think augments our responsibility, and that is that the creation of a child isn't an accident. It's not the case that the creation of a child is some unintended consequence, something that we knew there was a minute chance that might happen that we tried to avoid. You've actively engaged in a process to help bring about a new life that's going to be dependent on all sorts of things for that life to go well. And the fact that you've done that augments your responsibility. Normally think that people have increased responsibility in cases where they act with intention than in cases where they do things by accident. And so I think the case for responsibility in the gamete donation case, or gamete provision case, is stronger. So that's sort of an augmented parity argument. Okay, the next thing, which I'll go through also kind of briefly, what kind of responsibilities are we talking about? So the first thing I want to say is I don't think that these responsibilities are necessarily parental, right? I think that though children require parenting, this does not necessarily have to be provided by the genetic parents, right? I think that individuals who engage in gamete provision have to make sure that their biological offspring have decent lives. That's what they're obligated to do. and that can result in a whole bunch of other different kinds of obligations other than parenthood. So, for example, making sure that they have access to medical information that might be important for their health interests, being open to, it might be the case that gamete providers have an obligation to be open to forming relationships with their offspring, because even if not everybody feels this way, some people definitely feel very distressed by not knowing anything about their genetic progenitors, and individuals should know this going into donating, providing gametes. And so this is one place where they should be willing to step up and help somebody's life go better if they're suffering as a result of sort of lacking this kind of information or this kind of relationship. Though I do want to say that I think that sort of being open to forming a relation doesn't mean that you have an absolute duty to form a relation. I think you have to be at least prepared to consider it and take it seriously and determine whether or not you're going to pursue this based on the particular circumstances and interests of the particular individuals, and what they might need in order to sort of feel whole. And I think that in certain kinds of extreme cases, gamete providers might have an obligation to provide resources to the families of the individuals who are raising their biological offspring. Because again, they have an obligation to make sure that their children's lives go reasonably well. And so that means that in cases where social parents become destitute or cases like that, you might have the genetic progenitors might have an obligation to provide resources. Because again, I think that at most they're able to delegate their responsibilities to take care of these children, not transfer them. There's a case in California, which I think was mentioned in the last talk, which is REMC, which kind of illustrates cases where you, I'm not going to go into the details of that because we're short on time. Am I right about being short on time? But there are cases where you have sort of extreme tragic breakdowns in family life, and it may make sense that the gamete provider is the best placed person to help take care of this child. And I think that follows from the obligations when you donate gametes, because you have to make sure that this person's life goes reasonably well. Okay, so the last set of sort of unresolved questions, and this is sort of an area where my research is sort of heading right now, which is what sort of ultimately underlies or gives rise to these kinds of responsibility. And this is a question I haven't sort of directly answered yet. One common model is the compensation model. So, and I think Shauna Schifrin is probably the most notable defender of this kind of view. Here the idea is that parental obligations are a kind of compensation for exposing offspring to potential harms. And I think that that's not really the strongest way to sort of conceptualize parental obligations or procreative responsibilities more general. My main reason for this is because I think that that justification leads to antinatalism, or otherwise put the view that reproduction in general is impermissible. Why is this? Well, we normally only have to compensate other people for harms we cause when we've harmed that individual and the harm that we caused was wrongful, right? If we think about it, we harm people all the time in ways that don't generate a requirement to compensate. So for example, this is going to rest a little bit on what our conception of harming is, but normally we say that we harm somebody when we made them worse off than they otherwise would be. But if we think about this, we harm people all the time. Sorry. So if you think about it, if you apply for a job and you get the job and somebody else doesn't, you made them worse off than they otherwise would be. But you don't owe them any compensation because that kind of wrongdoing, that kind of harm wasn't wrongful. If we think that we base procreative obligations on compensation, it means that we have to think that there's something, it's not only were the risks imposed harmful, but they're also wrong. And if they're wrong, then why should we permit reproduction at all, right? Because it's wrong. So I think that's why we slip into antinatalism. One way to get around this is to appeal to something like strict liability, which is a concept where we think that sometimes people have obligations as a result of harm, even though that harm wasn't wrongful. And there's certain cases in the law that recognize this. So, for instance, blasting, if you're using dynamite to make a hole in the side of a mountain, if you're engaging in this activity, you have obligations to whoever gets injured, regardless of what precautions you take, even if we think that engaging in this activity wasn't wrongful. And that's one way we might try and get around this problem of compensation leading to antinatalism. But I think that strict liability as a concept is really theoretically fraught, and there are scholars who think that actually strict liability is either undefensible or doesn't actually exist in the law at all. And so I think there's sort of problems looking to that principle to help us resolve the problem. The way I suggest we try and move forward is by thinking that procreative responsibilities are grounded in beneficence. So beneficence is the idea, is the term philosophers generally use to refer to, I think, intuition we generally share, that we have an obligation to take interest and improve the well-being of people around us, right? So regardless of whether we've wronged them or harmed them. I think that in certain circumstances, so normally beneficence is considered an imperfect duty, so you are not obligated to be beneficent to everybody all the time. It's not the case that everybody you possibly could help, you have to help, but at least you have to help some people some of the time. But I think in constrained cases, the duty of beneficence becomes a perfect duty, meaning that you have no choice but to act in a beneficent manner. One, I think, clear case of this is the duty of easy rescue. So again, the case if you're walking by a pond and you see somebody that's drowning and you easily save them, you have an obligation to save that individual. Many people try and defend this by appeal to the principle of beneficence. And often the idea of beneficence is grounded in the idea that we recognize other people as having a kind of fundamental value. And if we recognize other people as having a sort of fundamental value, that means that we have to have a certain attitude towards them. We have to see them as valuable and promote their interests in certain kinds of ways. So how I think this relates to the question of procreative responsibilities and gamete provision is I think that if you go to the effort of helping bring into existence an individual, but then don't take any further interest in their well-being, you haven't really fully taken seriously the ethical magnitude of what you've done, right? I think that if you create an individual and then just maybe take some initial steps to make sure things go okay, but then step back and sort of take no further interest, you have not properly taken into consideration the value of the individual that you created and the moral importance that their suffering might have. And so I think that might be a case. I don't have a fully worked out argument for this. This is where I'm trying to go. But I want to argue that procreation is somewhat similar to the pawn case, right? To fail to recognize or to fail to take a further interest in the individuals you intentionally create is to fail to recognize the value of the humanity of other people. Okay, I'm over time. I'll stop there. Thank you.
Thanks very much, Reuven. That was super interesting. I have a question about your distinction between transfer and delegation, and then how that intersects with the 4 responsibilities that you identified. So 2 of the responsibilities, providing medical information and being open to forming a relationship, seem like they can't even be delegated. So the distinction between transfer and delegation seems like you don't need that to get those 2. If gamete donors have those, it can't be that someone else, you go provide your medical information. Like that's not helpful. It's got to be my medical information, and it's got to be me there. And so that can't be transferred or delegated. The 2 others look like they could be transferred. So providing resources in extreme need and taking on the parental role in extreme circumstances. And so my question is, how do we think about whether these are cases where transfer can happen or not? And I guess I want to know what you think about someone, if we have a view like Sally Haslanger, who says we should take like an ameliorative approach to these questions and ask, well, what are we going for, right? There's not a metaphysical fact behind the question, are these responsibilities that can be transferred or merely delegated? We have to ask, well, what are the interests involved? What are the outcomes? I mean, I know you don't like this. What are the outcomes that we're interested in with respect to equality and the competing interests and independent considerations of justice? And so you've got to get into those thorny issues to figure out whether we decide Whether these are cases where transfer is going to happen, or whether you say no, the best you can get is delegation.
Okay, so good question. So first, I think it's true that some obligations are neither transferable nor delegatable, or however you would pronounce that. I'm not sure. So that's true. I disagree that the other two, so providing assistance in case of extreme need. Well, yeah, I'll use that as an example. I disagree that that is transferable. Why? So if you think that you have an obligation to make sure that somebody's life attains a certain level of well-being, and you say, okay, I'm going to have my brother, make sure that my offspring have enough to eat and have proper access to education, all that kind of stuff, and then I find out that he's failed. Right? He's taken the money I gave him to do that, or he promised to do it and he didn't do it. I'm not off the hook, just like in the library case, because I owe that obligation to the child, right? And so if I have an obligation to a specific individual, nobody but that particular individual can absolve me of that obligation. Because that's what it means to have an obligation to somebody, right? Just like if I promised you that I borrowed something, so again, the library case, if I borrowed something from you and then had somebody else promise to return it, and then you came to me and said, I want that thing back, you wouldn't accept it as an excuse. Mike, well, I said that somebody else promised they would do it, so you can't hold me responsible anymore. So this does assume a certain model of responsibility, right? But I think this assumes sort of the classic way we conceive of responsibility in the one-night stand case. So what this argument is supposed to show that people who think they can get around the problem of whether the same kind of responsibilities arise in gamete provision cases as do in one-night stand cases can't appeal to the transfer of responsibility to just sidestep that problem, right? So that's what that argument's supposed to show. Yeah.
Okay, yeah, go ahead.
I had a follow-up. Yeah, so just to follow up on this, I think with respect to the promising case, it's because the promisee has a right against you, right? Mm-hmm. And so the parallel with the children's cases, you're assuming that the child has a right against the biological parent to be parented by the biological parent, or the Gammy provider, et cetera, et cetera. And that's exactly what's at issue, right? Because some people, I think you only talk about the responsibilities of the Gammy providers, but I think you also need to bring in the equation of the rights of the Gammy providers, right? And so in the case of so there's a live issue about whether they have the right to, as it were, seed their, can they give up their gametes, right? And can they can they waive their rights to certain things, right? Can they, cede it to other people, et cetera, et cetera? And let me just say one thing, like take adoption cases where someone might say, I'm not in the position to take care of the child, so I'm going to give up my child for adoption. And so, there's sort of all these legal things that goes into it where you waive your right. And once you waive your right, it's absolute, right? You cannot sort of later on say, oh, I want to come back and, do this and that, et cetera, right? Once you've waived your right. And then it's also the case that if the parents of the adopted parents, if they were to be deceased, it doesn't go back to you, right? That there are other procedures for that, so.
Okay, there's a whole bunch of questions there, and I hope I can remember them all. So I'll start with the first one, which is that in a certain sense, you're accusing me of begging the question. And I don't think I'm doing that. So I think what my distinction between transfer and delegation is supposed to show is that people who think that they can avoid the question of whether the same kinds of responsibilities that arise in one-night stand cases arise in gamete provision cases by saying, well, even if they did, these could just be transferred away, they're wrong. Because the kind of responsibilities that we think arise in one-night stand cases are responsibilities towards a certain individual. We normally think that, in the case of the one-night stand case, we normally think that the child has a particular right against an individual for support, right? So you can't avoid that question by saying, well, if that did happen, they could just be transferred, because that kind of responsibility, at least on my view, isn't transferable. based on this distinction. Now, we can dispute whether that kind of responsibility arises, and that's a separate question. But all my, oh, sorry, I closed the lid and I, do you want me to do this? Should I just leave it down, or? Okay. So that's what the example is supposed to show. Is you can't avoid the question of whether responsibilities initially arise, which is what the transfer argument is often done. We can just avoid this question entirely. And I want to argue that you can't avoid the question entirely, because certain kinds of responsibilities can't be transferred. Okay, the second question was, what about the rights? Is that right? What about the rights of gamete providers? Or, so I think that we can separate obligations and rights. You can think that you have an obligation to ensure that somebody's life goes a certain way and to take steps to ensure that without necessarily having the right to interfere in the sort of daily running of that individual's lives or even make important decisions for them. We can separate these two things. So you can have individuals who have child maintenance obligations but don't have any parental standing, right? They have no right to make decisions for the child. That is perfectly possible. And so I think, so I want to distinguish between parental obligations and procreative obligations. And I think that parental obligations, and parental rights, for that matter, arise out of the actual practice of parenting. So I have a sort of relationship view. They arise out of actually taking care of somebody. And that's what gives you standing to make decisions on the behalf of a child and have the kind of rights and responsibilities that we think parents do. And that's separate from what I think the kind of obligations that gamete providers would have, which is sort of more removed. And so I don't think that the obligation to help make sure somebody's life goes a certain way necessarily gives you any rights whatsoever to intervene in it. So to give an example, if we're driving down the street and you crash into me, right, and so now I need medical treatment, you might have an obligation towards me to cover my medical costs, but you have no right to decide what doctor I go to, what hospital I go to. You can have obligations without corresponding rights. So I don't think that is that absurd an idea. Was there a third question in there? Or?
Thanks. Thanks for your talk. I really enjoyed it. I was a little bit confused at the end, and maybe it was just because you were rushing, where you said that the person who, a gamete provider who doesn't, take some responsibility is similar to somebody walking by a child in a pond and failing to recognize their humanity. But that makes it seem like anyone would be equally responsible. So it's more like someone who threw a kid into a pond, right, than like someone who's just walking by a pond, because the way you put it makes it sound like we would all have that responsibility. I don't think that's what you meant, or maybe I didn't understand. Thank you.
No, yeah, so I think you're right. Yeah, so I was rushing a bit. So I want to argue that in certain cases, when we act in certain ways, that gives a special obligation of beneficence to an individual to promote their well-being, and that arises when we place those individuals in circumstances where they face certain kinds of risks without their consent. So sort of like the camp example again, right? Even if I think that this trip will be overall beneficial, even if I don't help stop this person from suffering from the bee sting, because I took them there, I still have this special obligation that isn't grounded in the fact that I've made them worse off overall.
Or they can walk by and stop.
Yeah.
For your talk, that was really interesting. So I have a question and a comment, and my question actually follows up on Rivka's. So why wouldn't the lab techs and the fertility doctors also be in the position of throwing the kid in the pond? Or why wouldn't they also have the same duties of beneficence that the gamete donor has?
Yeah, so I bite the bullet on this gallantly, and I say that they do. I think that if you are in the business of making people, you have an obligation to make sure those people's lives go reasonably well. And so I think that the view that fertility companies we're just helping people and that's all that matters, I think that that's false. You're doing something much more morally weighty. I think it's not unusual for us to feel that way. So I think we normally hold arms companies, for instance, responsible for the way their products are used, even though they're just selling things on the market. And so the fact that we're involved in this sort of commercial enterprise where other people are going to be making use of your services doesn't insulate you from responsibility.
Thanks. And then I just had a comment, and I think this is like a friendly amendment. It's not meant to be critical at all. But when we talk about moral responsibility and causal responsibility in the context of sex, I think it's important to think about the context. So I agreed with your point at the end that the gamete donor is more morally responsible than the person who accidentally impregnates a woman in a one-night stand, or the person who accidentally gets pregnant. In a one-night stand, because the gamete donor is intending to be part of this causal process where they create a child. So there's more moral responsibility. And just in thinking about the differences in responsibility there, I think I always, and this is sort of a criticism, not in principle, but of the way that the causal account often gets applied, particularly in our intuitions. When we think about the moral responsibility of people who accidentally procreate in a one-night stand, when we're assigning moral responsibility, it's important to recognize that this is in a society where there's systematic misinformation about sexuality and procreation and abstinence-only education, where there's limited access to abortion and contraception, and where there's widespread sexual assault of women. And so all of those things, I think, often affect moral responsibility of people who become accidentally pregnant. And so I think that just adds to your point that actually the gamete donor is often more morally responsible.
Yeah, so I entirely agree. So I think there are many cases where individuals who become pregnant by accident might not have responsibilities. Whereas I think that's highly unlikely in the case of gamete provision cases, unless somebody maybe was sort of forced into gamete provision or something. But yeah, so I actually, I don't have a firm stance on the way obligations arise in one-night stand type cases. I'm much less certain about that. And I think there might be a strong case to be made that responsibilities don't always arise depending on the particular circumstances. But I think that gamete provision is not a case like that. So yeah, I agree.
Thank you. So I'm totally sympathetic to your claims and totally sympathetic to the idea that people are way too cavalier about creating people, okay? But I wonder whether it is a problem for you, for your delegation rather than transference, because one of the differences between transfer and delegation in your case is that in the delegation case, the person who delegates can always get the thing back. So if I delegate to you to take care of my child, as a babysitter, I can, at any time say, I'm gonna do that. Or if I delegate to you as Charlie, to do the web page, I can say, you know what, I ultimately think I'm gonna do it myself. Which seems to then imply that the donor provider can at any point actually claim that, those responsibilities that they have delegated.
Okay, yeah, so that's a good question. So the argument is normally when we think about delegation, we're able to sort of rescind our delegation, right? So I think that doesn't arise in this case because I think that what's delegated isn't your parental duties. It's other kinds of duties to make sure that somebody has a certain kind of a life that goes well to a certain extent. I mean, there's sort of vagueness. And part of that is to make sure that somebody is parented. But I think that once somebody is but I think that parenthood arises separately. That arises from a sort of relationship interaction. And once a parenthood bond has been formed, the gamete donor can't take, or gamete provider can't take that back because they're not in a position to parent. That's now become a task that they cannot fulfill themselves because they have not formed the requisite relationship to make parenting possible.
Has more weight than my wanting to take back those responsibilities. But couldn't that be the case, you haven't formed any bond yet? Sorry.
So you thinking about a case where you've provided gametes and then, at 8 months or something, you suddenly decide,
yes.
Yeah. Okay. That's good. So that's a tricky question, and that is something that I don't have a firmly worked out view on. And that's something that I really should try and work out. I think it's complicated. So at least in some cases, in the case of gestation, so if somebody's you have a woman serving as a surrogate, I think it's quite clear that the surrogate's claim to be the parent is the strongest because that person has done a lot of, has already shown commitment. I think that you do start forming a bond with a child before they're born, all these kinds of things. So I think that gives primacy to, in the case of surrogacy. In cases of gamete provision, it's more complicated. And so I think depending on the circumstances, there might be cases where a gamete provider might be able to rescind. I'm not sure though. It would be context dependent, and I don't have a firmly worked out position. But I think it's a good place to push and something I should think about.
So I have a slightly different perspective just to lend to some complexity to the conversation. So I'm a psychologist, and I've worked in fertility clinics for years, for decades. And one of the things I have done is screen egg donors and sperm donors. And I personally am of the view that the business of fertility is more to be blamed than the donors in many cases. The donors that I have met with for decades, for the most part, and I mostly screened egg donors because for a long time they didn't really do psychological screening of sperm donors. So most of them were young women who truly and deeply were motivated to help. And they believed the way that they could be the most helpful was to hand over their gametes and walk away and let the child and the family have as close to normal a life as possible. Like they believed that was what was best for the child and the family. They weren't trying to be derelict in their duties. They were trying to do something good. And they're young women who are led by the agencies and the clinics and the business to believe, oh my gosh, you're doing the greatest thing by doing this. Nobody is counseling them at all about what the truth of what they're getting involved in is. They're really quite young and naive. And I think as I sit here and for this weekend, and it's been so moving, really, amazingly moving for me, I feel so sad because I think that donors who heard your perspective and who probably now have done it and are hearing your perspectives probably feel so badly that they participated in something that ended up hurting people, because that's not where most of them are coming from. Even egg donors would say to us, oh, you don't need to pay me. They're going through IVFs, and they're saying, you don't need to pay me, I just want to help someone. So they're really not as, they're not callous in what they're doing. They actually think they're doing something really helpful and wonderful. So I think it's the agencies, and I think that one of the big problems is that the agencies are afraid to let the donors know, really how complicated it is, because then not as many people would donate. And also, they're afraid of future contact, because in a way, by not having there be future contact, the agencies don't ever end up being, responsible for when things went wrong. And lastly, the agencies lead the donors to believe that the parents, the intended parents, have been screened. They all say, well, I know the parents have been really well screened, and they're going to such lengths, to have a baby, so they're going to be wonderful parents. And the fact is, the parents aren't being screened. They're not being screened at all. Yeah, yeah. So the donors are actually being misled about, this idea of handing over their eggs, they're being handed over to someone who's in good hands.
So I'll just say one thing quickly. I think one thing that I think one plus from my view is that it doesn't imply that that in most or in many circumstances, gamete providers have really weighty ongoing obligations that they have somehow failed to do. In some cases, that might be the case, but in many cases where people are happy and their lives have gone well, then the Gammy providers don't owe anything more in those cases.
I just wanted to clarify that there are some cases in which, without history, intended parents have been screened, particularly when we're talking about disability or sexual orientation, when there's then a concern that's come about their fitness. So there have been times where that has happened.
For the wrong reason.
For the wrong reason. Yeah.
Yeah, I mean, so I have a separate question, but on this, I mean, I do think, we don't screen people who are forming families with children through heterosexual sexual intercourse. And there are ways in which we have a long history of checking people's ability to be parents based on characteristics that I think those of us in the room would think are illegitimate characteristics. So we should be careful what we ask for. So I just want to follow up on Ema's point, which, so I guess I wanted to know what your account of the parenting is then, because I could imagine, so it sounded like in response, you were saying, well, they haven't formed that relationship with the child, so they can't come in. So that sounds like partly what you're saying is what matters is the attachment relationship that the parent forms with the child, so the child's perspective on this relationship, which would then mean, for purposes of those who study this, at what point does the child have an attachment relationship, which would seem to suggest that gestation actually might not matter, and that what matters is the child's experience with this person who's parenting, but then would suggest that the Gammy provider, as well as the person who placed the child for adoption would be able to come back in at a particular point if it's before the attachment relationship is formed and say, I'm perfectly capable of doing this. So I don't understand what the account is in which they're not able to do the thing that you're saying they can't do.
Okay, good questions. Let me think for 1 sec. It's always good to think before speaking, though I often don't do that. So exactly when the right kind of attachment happens, that's a difficult question that's going to be largely empirical and something that I don't have a fully worked out view on. And so yeah, I do accept that there's a problem with my view about that there might be a window in time in which the Gammy provider may be able to rescind the delegation prior to that relationship arising. And that may or may not be problematic. I mean, often in adoption arrangements, there's sort of a cooling off period, a period of time. So
in many states, they can wait for 72 hours. She can't once under state law in many states, once she's actually waived the rights for purposes of that 72-hour window, if she has chosen to waive her rights, then she can't rescind on that waiver. Right. Right, but in his view, the 72 hours.
Right, but she hasn't signed a if she
I've
hasn't
not
signed
given
a
a time
prenatal
frame.
agreement, then she has 45 days in most states to change her mind. It's only if they have a prenatal agreement.
Okay, I mean, so, yeah.
Let me keep on going. So that might be a worry. I mean, I think it is a worry, and it's something that my view needs to work out more. Sorry, there was a. So yeah. And what relationship matters? So I don't think that. So I think this is a partial response to the first question too. I don't think that the only thing that matters is the child's perspective on the relationship. So I know that the law likes to say things like we're only interested in the best interest of the child and things like that, but I think that that's not a particularly useful principle because I think it's incredibly vague and not true. So for example, if you had a neonatal abduction, right, that gets discovered 10 years later, right? So you have an individual who has really only been parented by this one person. Maybe they did a perfectly good job of parenting, right? Are we going to say that, well, so this individual is now the legitimate parent and there's no redress to be had? And in fact, no wrong happened. Nobody was deprived of a parent-child relationship because there was no parent-child relationship between the person who, the intending parents and the child to begin with. So I think that for us to make sense of our intuitions about these kinds of cases, we do have to think that the interests of the parents also matter. So I think so this is another thing that I have not worked out perfectly well, but I think that certain people have a claim to become a parent, right? And that's different from actually being a parent. And part of this problem rests on working out which individuals have the strongest claim to form the kind of relationship that is meaningful. And I think that the law might have an interest in protecting certain individuals' claim to become a parent, even if we think that it's relationship that matters. Otherwise, we end up with this problem of abduction cases, right, where we think that no, so I mean, and I think that might be a concern for the view that you proposed earlier as well, which is if you have this purely functional view, right, what do you do about these kinds of cases as well? You have to fall back on some other kind of principle that might not be looking solely at the interests of the child involved.
I'll just add that some years ago in Michigan, there was a very famous case of the sort you're describing. I believe the court did return the child to the biological parents, but many, many people thought that this was wrong. So you might want to look up.
Well, yeah, so I think this is a case where what we desire from the law and what morality requires come apart, because I think that the law might have an interest in preventing people from engaging in neonatal abduction. And so that might ground, so that would ground this kind of practice of not recognizing parenthood that's arisen in these kind of nefarious ways, even though we might think that, morally speaking, that individual is in fact, the person who abducted them is in fact the parent. And so this is where I think the questions get much more complex, yeah.
Thank you for your talk. My question, as you were going through the distinction between transfer and delegation, I think you really hit on a systemic problem with the industry, and where this all falls down is that the donor is responsible for, in some way, providing family medical history, having some sort of relationship, and he's attempting to delegate the responsibility of deciding how many of these relationships there are going to be, how many children are going to be born with their gametes, when the establishment that he's delegating these responsibilities to doesn't have enough information to make those decisions effectively for him, and also holds a conflict of interest that prevents them from objectively making those decisions. And by the way, I have over 50 siblings.
Yeah, so I think that an alternate route to looking at where we should place donor limits is to look at this obligation, right? And we might think that, given the fact that there are some people who feel very strongly that they are harmed by not having any kind of relationship with their biological parents, and this is something that's predictable, that might give us reason to limit the amount of offspring people have, just because we might think that these individuals might have an obligation to at least form some kind of responsibility, form some kind of relationship in cases where individuals are very troubled by the fact that they don't have this kind of relationship. And that might be another way we can sort of look at that question of donor limits, aside from questions about unintentional consanguinity and things like that, which is sort of normally the way this is discussed.
So when the responsibility is being attempted to be delegated and that's not possible, it seems that it comes into the third category, and that's abandonment of responsibility.
Yeah, so I think it's morally problematic to knowingly put yourself in circumstances where you will not be able to fulfill the obligations that you know are likely to occur. Yeah.
So in the last few minutes, I'm going to take the the luxury of adding something, and that is, I would be interested in knowing whether part of what we find objectionable in cases where you have 50 siblings, it strikes me as, it reminds me of our intuitive objections to human cloning. And that is that each of us has an interest in being unique. And now, of course, you are still unique despite having half siblings. And yet, well, if there are too many children of this father running around, I have been, in a way, devalued. So at some point, I'd be interested in whether your objections are related to that. Other questions? Yes?
So I know you guys keep talking about the industry and everything, but I was just wondering if the panel and the speakers and the people that counsel, I'm just curious if you know that there are people out there in Facebook basically offering their seeds to people. And they use terms like natural insemination, partial insemination. Are you aware of these things out there in Facebook, the Joe donors that do it in the back of a van?
So yeah, so I'm aware that there's sort of this practice of gamete provision that happens sort of outside of a medical context, and some places have actually explicitly enacted laws that recognize gamete provision and sort of intentional parenthood in these cases, even in the absence of these procedures happening within a clinical context. So one example, there's a few provinces in Canada, so I'm pretty sure British Columbia now recognizes gamete provision arrangements written on the back of a napkin, for example. So yeah, so I am aware. Yeah, I'm.
And do you feel that's ethical?
Do I feel that's ethical? Well, I don't think that anything magic happens when you donate gametes through use of a clinic. I don't think that the medical context somehow fundamentally changes the moral the moral requirements of any parties whatsoever. I think if this is happening without any without proper information about what the obligations are and understanding what legal ramifications might exist, then it raises questions about proper consent and whether people fully understand what they're getting themselves into. But I think that it doesn't change, and so for me, that's what raises problems. But I think that like the case that I mentioned, I don't think that the method of insemination has any importance on the resulting responsibilities that arise. So I think that a turkey baster is no different than a syringe, and I also think that vaginal sex is no different than the turkey baster and the syringe either.
Like strangers,
Yeah.
or other strangers on Facebook to have his children, and he prefers natural insemination.
So the fact that the fact that somebody is advertising this in an open way, I'm not. It's going to be context dependent, I think, whether it's predatory or not.
I'm sorry, I'm going to have to cut off the discussion. We need a few minutes to rearrange things for the panel of the speakers, which I mentioned before. So just give us a couple of minutes to set up some chairs and change some lighting, and we will move on from there. Thank you, Reuven.